I would appreciate if you would read disclaimer written in the end of this document, regardless before or after listening, reading, or so this document. Even if you will not, it will be recognized that you agree with the disclaimer, when you listen to, read or so all or a part of this document even once. Thank you very much for your understanding and cooperation. Law Translation Urban Planning Law of Japan. Article 1 to 6 Chapter 1 General Rules, Purpose. Article 1 This law has purpose to contribute to promoting public welfare and to equilibrium development of nation land with systematic maintenance and steady development of urban by determining necessary matters like project, restriction, decision procedure, content, and others about urban planning. Basic Principle of Urban Planning. Article 2 Urban planning defines basic principle to rationally use land under suitable restriction for holding functional urban operation and healthy, cultural urban life with appropriate balance of agriculture, forestry, and fishery. Responsibility of nation, local government, and resident. Article 3:1 Nation and local government have to strive for adequately execution of urban planning like development, maintenance, and others of urban. 2. Urban resident has to strive for building good urban environment with cooperation for measure to achieve purpose of this law by nation and local government. 3. Nation and local government have to strive for providing information and dissemination of knowledge of urban planning for urban resident. Definition. Article 4:1 Urban planning in this law is defined under provision in next chapter in Plan of Urban Area Development Project. Maintenance of urban facility and land utilization for execution of consistent maintenance and adequate urban development. 2. Urban planning district in this law is district specified by next article, and quasi-urban planning district is district specified by Article 5:2. 3. Area and zone in this law is area, zone, or town block showed in respective item of Article 8:1. 4. Promotion district in this law is district showed in respective item of Article 10:2. 1. 5. Urban facility in this law is facility showed in respective item of Article 11:1, determined by urban planning. 6. Urban planning facility is facility showed in respective item of Article 10:1, determined by urban planning. 7. Urban Area Development Project in this law is project showed in respective item of Article 12:1. 8. Urban Area Development Project Scheduled District is scheduled district showed in respective item in Article 12:2. 1. 9. District Plan etc. in this law is plan showed in respective item in Article 12:4. 1. 10. Building in this law is building defined by Article 2:1. of Building Standard Law of Japan, that is Law No. 201 in 1950, and architecture is architecture defined by Article 213. 11. Specific facility in this law is facility that may cause environmental deterioration in the vicinity like a concrete plant or so specified by Cabinet Order, which is hereinafter referred to as Type 1 specific facility, or a large-scale facility like golf course or so specified by Cabinet Order, which is hereinafter referred to as Type 2 specific facility. 12. Development action in this law is change of compartment, form, and nature of land mainly under purpose of building specific construction or building. 13. Development district in this law is district of land for development action. 14. Public facility in this law is facility utilized for public use like road, park, or so specified by Cabinet Order. 15. Urban planning project in this law is project of urban area development and of maintenance of urban planning facility under approval or permission pursuant to Article 59 specified in this law. 16. Constructor in this law is person or company who executes urban planning project. Urban Planning District, Article 5:1, Prefecture specifies urban planning district needing comprehensive maintenance, development, and preservation for one body urban with consideration of future transition and current situation of matters identified by ordinance of the Ministry of Land, Infrastructure, transport and tourism about traffic, land use, population, natural and social condition or so, and also including center urban area of town or village satisfying requirements set forth by cabinet order about number of workers, population, or city and others. In the case above, when it is needed, prefecture can also specify urban planning district in a place over outside of the applicable municipality. 2. Prefecture specifies urban planning district needing maintenance and development for industrial city, new residential city or other kinds of city. Urban Development District under *Chubu Area Development Maintenance Law of Law No. 102 in 1965, Kinky Area Maintenance Law of Law No. 129 in 1963 and Capital Region Maintenance Law of Law No. 83 in 1956 in addition to the provision of the preceding paragraph above. *Chubu means range of around prefectures like Ike, Shizuoka, Yamanashi, Nagano, Gifu, Fukui, Ishikawa, Toyama, and Niigata. *Kinki means range of around prefectures like Mie, Nara, Wakayama, Osaka, Hyogo, Kyoto, and Saga. 3. Prefecture has to get agreement from Minister of the *MLIT after discussion under Ordinance of the *MLIT with prior listening to opinion from Urban Planning Council and also relating prefecture and municipality for specifying urban planning district under Article 5.1 and 5.2. 4. Minister of the *MLIT specifies urban planning district covering over more than 2 prefectures regardless of Article 5.1 and 5.2. after prior listening to opinion from relating prefecture. In the case, relating prefecture has to listen to opinion from Urban Planning Council of Prefecture and relating municipality before telling opinion to Minister of the *MLIT. 5. Specifying urban planning district is published in public notice under Ordinance of the *MLIT. 6. The provisions of the preceding each paragraph are applied for change and abolition of urban planning district. *MLIT is acronym for Ministry of Land, Infrastructure, Transportation, and Tourism of Japan. Quasi-urban planning district, Article 5.2.1. Prefecture can specify quasi-urban planning district to certain district recognized in occurring issue of maintenance, development, and preservation for one body urban in future in neglecting of environmental maintenance or consistent land use with consideration of future transition and current status about other matters specified by the ordinance of the *MLIT, land use regulations situation under agricultural promotion area. Maintenance Act of Act No. 58 in 1968 and other laws and also natural and social condition in addition to including district to be developed of site area or constructed of many buildings and other facilities in current or future in district out of urban planning district. 2. Prefecture has to listen to opinion from Urban Planning Council of Prefecture and also relating municipality before specifying quasi-urban planning district. 3. Specifying quasi-urban planning district is published in public notice under Ordinance of the *MLIT. 4. The provisions of the preceding 3 paragraphs above are applied for change or abolition of quasi-urban planning district. 5. In a case of specifying urban planning district in whole or a part of quasi-urban planning district, the quasi-urban planning district is reckoned to be abolished or changed to other than the district that overlaps with the urban planning district regardless of the provisions of the preceding paragraphs above. *MLIT is acronym for Ministry of Land, Infrastructure, Transportation, and Tourism of Japan. Basic Research of Urban Planning, Article 6.1. Prefecture takes survey of future perspective and current status about traffic volume, land use, urban area site, size of working population by industry category, population, and others specified by the ordinance of the *MLIT for basic survey of urban planning in approximately every 5 years about urban planning district. 2. Prefecture takes survey of future perspective and current status about land use and others specified by the ordinance of the *MLIT for basic survey of urban planning according to necessity about quasi-urban planning district. 3. Prefecture can request necessary cooperation like submission of material and others to relating municipality according to necessity for basic survey under the provisions of the preceding 2 paragraphs above. 4. Prefecture has to notify the mayor of relevant municipality about basic survey result under the provisions of paragraph 1, or 2, above. 5. The Minister of the *MLIT can request necessary report of basic survey result under the provisions of the preceding paragraphs 1, or 2, above to Prefecture for enforcing this law according to necessity. *MLIT is acronym for Ministry of Land, Infrastructure, Transportation, and Tourism of Japan. Disclaimer: 1/3, Copyright 2021 by BISAM Urban Real Estate Society Institute. All rights reserved. No part of any content in this channel, which will be referred to as the contents after here, may not be reproduced, stored in retrieval system, or transmitted, in any form or by any means, in any written, electronic, mechanical, photocopying, recording or otherwise. The contents are for personal use only. You cannot amend, distribute, sell, use, quote or paraphrase any part or all the contents within this channel. While the author have used his effort in preparing the contents, the author make no representation or no warranties with respect to the accuracy or completeness of the contents in this channel, and specifically disclaimer any implied warranties of merchantability or fitness for a particular purpose. The author assumes no responsibility for any errors or omissions. No liability is assumed for damages that may result from the use of information contained within the contents. Disclaimer: 2/3, Copyright 2021 by BISAM Urban Real Estate Society Institute. No warranties of any kind are declared or implied. You acknowledge that the author is not engaging in the rendering of legal, financial, medical, or other professional advice. The contents in this channel have been derived from various sources. The author is not licensed to sell any product or service as any broker or dealer. Nothing herein is intended as brokerage, investment, tax, legal advice, as an offer or solicitation of an offer to sell or buy, or as an endorsement, recommendation, or sponsorship of any company or fund. The contents in this channel is mainly of the nature of general comment only, and does not represent professional advice. It is not intended to provide specific guidance for particular circumstances, and it should not be relied on as the basis for any decision to take action or not take action on any matter which it covers. You should obtain professional advice where appropriate, before making any such decision. Disclaimer: 3/3, Copyright 2021 by BISAM Urban Real Estate Society Institute. The author accepts no liability whatsoever for any direct or consequential loss arising from any use or the contents, including your connection to each the website, PDF, or so showed as reference. The contents contained herein may not be suitable for your situation. The author shall not be liable for any loss of profit or any other commercial damages, including but not limited to special, incidental, consequential, or other damages. You bear responsibility for your own research and decisions, should seek the advice of a professional before making any action, and investigate and fully understand any and all risks before any your action. No responsibility can be taken for any results or outcomes resulting from the use of the contents. You agree that no legal action can be taken against the author. Any use of the contents in this channel is at your own risk, including your connection to each the website, PDF, or so showed as reference. If you took any legal action by any chance, you agreed that it would be treated at Yokohama District Court as exclusive agreement jurisdiction court in Japan under law of Japan. the author has the right to change any the contents in this channel, but not limited to modify, discontinue, disable, terminate, and so on at any time without any prior notice, permission and so on. End.